Great. So we are back here in the Judiciary Committee and happy to be able to hear from Bor Yang of the Human Rights Commission. If you can identify yourself for the record and let us know what the commission is up to these days.
Yeah. Well, thank you so much for inviting me. My name is Bor Yang, and I am the Executive Director and Legal Counsel for the Vermont Human Rights Commission. And I know that you have some new members in the committee this year. So I'll sort of just start at the beginning and give you a little bit of a background and summary of the Human Rights Commission. And then I'd love to have an opportunity to talk to you all about sort of our legislative priority this year, since some of those bills may or may not come to you or committee, but definitely will come to you as a legislator to vote on, hopefully. So the Human Rights Commission is a state entity that was actually created by the legislature more than 30 years ago, and it enforces the anti-discrimination laws of the state. Some people are a little bit confused about what we do versus what the Attorney General's Civil Rights Division does. So I'm just going to clarify that the Civil Rights Division of the Attorney General's Office enforces the Fair Employment Practices Act as to private employers and municipalities. But the Human Rights Commission enforces the same anti-discrimination laws in employment as it relates to state agencies and departments. So if you are one of the 8,000 plus employees for a state agency or department, and you have experienced discrimination, you would come to the Human Rights Commission instead of the Attorney General's Office. But in addition to that, the Human Rights Commission also, and is the only entity that enforces the fair housing laws in Vermont, as well as the Public Accommodations Act. And the fair housing law is obviously anytime anybody experiences housing discrimination, either in mortgage loans, in looking for a house, in landlord-tenant, fair housing issues, they would come to the Human Rights Commission and the Public Accommodations Act. So public accommodations is any place that provides goods and services to the general public. And we typically understand places of public accommodations to mean your Walmart, your local grocery store, your gas station, your local business that opens its door to the general public. Definitely covers those. But Vermont enjoys a more expansive definition of places of public accommodations. And our courts have held that that also includes government entities and roads as well. And so that brings in a lot of cases also involving corrections and the police. Our statute includes in the definition of places of public accommodation, schools, hospitals as well. And so we get a fair amount of school-related harassment cases and cases in corrections and involving law enforcement, as I mentioned. We are made up of 5 commissioners who are appointed by the governor. In fact, Representative Kevin Coach Christie is our chair, and they are appointed by the governor and confirmed by the Senate. Their primary role is to hear the cases on a monthly basis and make a determination whether or not discrimination has occurred. Their other role is to hire me, the executive director, and I oversee a staff of, including myself, 6, 3 staff attorney investigators who investigate all those cases that I mentioned across those areas in the state of Vermont. We have 1 assistant, and we have a director of policy, education, outreach, Amanda Garces, who may testify before you at some point during this session as well. We do not have a full-time litigator, and it is something that I have asked for a very long time. It is very difficult to do this job and not have the resources to follow through and litigate all the cases where we do find that discrimination has occurred. So I will continue to ask for that this year, as I always do, and I would certainly love your support in ensuring that that happens. Any questions about just cases? Maybe I'll just talk a little bit about how cases come to us. So anybody can bring a claim to us. Oftentimes it's really as simple as a phone call. Sometimes it might be a referral from Vermont Legal Aid or ACLU or a community advocacy group. But most of the time it's a person in the community who's heard about the Human Rights Commission, who thinks that they have experienced discrimination and wants to file a claim. If we believe that it meets the threshold and the bar is low to get in the door, we'll open an investigation, assign it to one of our 3 staff attorney investigators. They will then interview witnesses, collect documents, and then try to help the party settle the case. And if they can't, then write an investigative report, which makes a preliminary finding that discrimination has occurred or has not occurred. And that's what goes before the commissioners, who hear from the parties and read the report and make a decision. These cases are very lengthy and time consuming. Sometimes the relationship between the employee and the employer is 3 years, 4 years long. We're talking about sometimes anywhere between 10 to 20 witnesses, lots of documents. And it's in many, while we investigate impartially and we don't represent either party, it's somewhat an adversarial process, in that some of the things that we need to complete the investigation, the lawyers on either side may not want to provide that. That can also create significant delays in the investigation as well. So yeah, that's the short of it. I'm happy to answer any question. I also would love to talk about some recommendations we'd love to make to the legislature about upcoming bills.
Let's start with any questions first, if there are any. Do we have any questions? Barbara.
So thank you. It's nice to see you. I would love to talk more about the full-time litigator position, because I know in talking to Coach just how important this has been, and know that it hasn't come to fruition. And I'm wondering, like, given the role that the Human Rights Commission has, one could see where an administration wouldn't necessarily want to fund a litigator. And I guess I'm curious if this position has gotten sort of shot down in the Appropriations Committee, like, and if before this year's appropriation, just being able to get data from you to try to help boost whatever we can do to not have the same result.
Yeah, well, thank you so much for observing that and saying that, so that I don't have to say the obvious. But yes, obviously, as you know, the governor creates our budget, and then that goes to appropriations. And it can be really a challenge to get support for something that isn't part of the budget to begin with. And as you all know, there are many, many competing demands upon the budget, the overall budget. And so there's also seems to be this statement that people make that there isn't enough money. But I don't necessarily believe that. I absolutely believe there's enough money. It's just a matter of where we prioritize and where we want to put that money. And I think that it is time that we prioritize equity, that we prioritize justice, and that we prioritize the Human Rights Commission that you all put into place more than 30 years ago, and that we need that support in order to make us the force that the spirit of the HRC statute was enacted in. And so yes, there's a lot of politics involved in that. So again, I would love your support. You know how busy you are, you know how busy Ledge Council is. And I think that I don't have to convince you how busy I am and why it would not make sense for me to be litigating 1, 4, 5 cases while I'm also doing the job of the executive director. So thank you.
Thank you.
Yes, thank you. And I'm guessing this might come up when you discuss legislative priorities. But if you can share kind of how caseloads are trending or claim, I don't know what the correct terminology is, in general, but also you mentioned kind of 3 different buckets, the housing, state employees and public accommodations. If you could break it down between those 3 areas as well, that'd be helpful.
Yeah, sure. So the number one type of case that we get is also the same type of case that happens across all state agencies and federal agencies too, and they are disability discrimination claims. They are the most frequent type of claim that is brought, but that isn't, we always have to be careful about numbers because that doesn't necessarily mean that people with disabilities are discriminated against at a more frequent rate. What's driving those numbers is that people with disabilities can bring claims of reasonable accommodations and modification requests. So they have this additional protection and ability to make additional requests of their employer, their housing manager, their housing provider, the place of public accommodations. And it's actually those reasonable accommodation and modification requests that are driving the numbers. We get a fair amount of housing cases. I would say the most frequent is probably the public accommodations cases because that is a broad definition under our statute. And then we do see some employment cases as well. In the last maybe 5 years, we saw a little bit of an uptick in race discrimination cases. We are certainly seeing a lot more school-related harassment cases come through the door. Is that because kids are experiencing harassment more? Is that because we're doing more outreach in that area? Is that because people have gotten a hold of our names and know that they could come to the Human Rights Commission? It's hard to say what the reasons are for the numbers and why they change from year to year. What we do know is that while our numbers don't tell the full story, there are other numbers at the state that do help us sort of analyze and are able to observe the prevalence of discrimination in the state. For example, Vermont Legal Aid puts out a report on fair housing testing where they actually send actors out to test whether or not landlords are discriminating. That's going to be a much more honest and accurate depiction of how prevalent discrimination is. And what that actually tells us is that people who are Black and people who have foreign sounding names, who are perceived not to be a Vermonter, actually face discrimination more than any other group of people in the state of Vermont. So while the HRC's numbers tell you that people with disability claims are actually like the most frequent type of case, we know from other things that that's the case. We are seeing like I said, we've seen an uptick in harassment cases. We also know from school-related data that lots of students, LGBTQIA students, students with disabilities, students who are Black, students who are Native American, report a significant increase in experiencing harassment in schools as well. So that also matches what we are kind of anecdotally collecting at the Human Rights Commission.
Thank you. I appreciate that.
Barbara.
So I've been wondering is there a National Association of State Human Rights Commissioners, and have other states, do they have different structures for how their budgets get set and or like best practices of staffing?
Yeah. There are state agencies like ours across, and there's a larger national organization that we participate in, but they don't necessarily collect that information. They're more like a training and outreach organization. I would say that the entity that we are most like is Maine. And in many ways, our statutes is also similar to New Hampshire somewhat. I did do a little bit of a comparison between the Human Rights Commission, Rhode Island, Maine, New Hampshire, and Massachusetts last year for appropriations to explain how many staffing they have versus how many staffing we have. And I can go back and certainly share that with you as well. One of the things that we have to consider is the fact that their statutes of public accommodations does not include schools. that there might be there might be a separate entity that hears school cases, and so they're not receiving those. So while it looks like you're comparing apples to apples because the statutes look the same in title, actually it's not necessarily true. And many of them don't do police-related cases also, because their definition of places of public accommodations is limited to the grocery store, the gas station, the business, and so forth, and not government entities. And so that comparison is hard, but I did kind of share that in a brief 2-pagers to appropriations last year to support why we need a litigator at the Human Rights Commission. I'm happy to share it again.
And given that you do have oversight over education and law enforcement, is it possible that some funding should appear in the education budget to cover some of the costs related to overseeing that?
Yeah, sure. I mean, I don't have an opinion off the top of my head about where the budget should come from necessarily. I certainly think that you want the HRC to be independent. And
Yes.
so you want to be mindful of, like, when budget is connected to any one agency or entity, what that means for oversight and governance. Yeah. So being mindful of that. Yeah.
Thank you.
All right, so let's hear what other things we've missed as far as what you have on the agenda for this session by.
Yeah. So one of the bills I would love to see passed this year is a bill that's been sitting at the legislature for a few years, and that's the Don't Darken My Door clause bill. When people file claims of discrimination and they try to settle those cases, employers use as a negotiation tool, they try to insert a clause in the settlement agreement that this person will never be rehired at that employer. That's called Don't Darken My Door, don't come back, don't apply for work, we're never going to have to rehire you. That's very problematic when you have an employer as large as the state of Vermont. It is the largest employer. That potentially eliminates this person from ever being rehired across all state agencies and all state departments. The same is true for a private employer that is large here. We are essentially saying to this person, potentially a woman who has faced sexual harassment, not anymore, I'll explain that, but a person of color, person with a disability, a person who identifies as LGBTQ, that just because you filed disclaimer discrimination, we get to use this tool to negotiate that you will never be rehired. We tell them, you have to leave the state of Vermont because there probably isn't going to be another place for you to work. That is problematic. Mind you, employers are not using this tool to get rid of problematic employees because they already have those tools. They have a whole grievance process to get rid of people who are problematic in the workplace. And it's time that we stop using it. In 2018, this legislature passed a Me Too movement bill that stopped punishing women who face sexual harassment in the workplace by prohibiting employers from using those clauses. So the question that is really left for us is, why do we continue to do that for people with disabilities, for people who are BIPOC people, for LGBTQIA employees, and so forth? This bill got the support of both committees in the chambers, and then it died in 2020 because of COVID. And then the bill was picked up again last year, and it got a second reading in the Senate, and then the Senate adjourned before it was passed. And that is really unfortunate. I see this as an easy pass, so I'd love to see your support for it. The second bill is—
One second real quick. What was the bill number last biennium? Do you recall? Do you have that?
320.
Okay. Is that H?
H.
Right,
H 320, yes.
That's the host.
Yeah, I remember that.
Another bill that is really exciting is amending our equal pay laws. Right now, our equal pay laws only cover sex as a protected class. It's time that we think about equal pay beyond sex and include race, national origin, disability, and maybe even more. And the reason why it's important for equal pay laws to include other protected classes of people is because equal pay laws do not require that an employee show that their employer intentionally discriminated against them in paying them differently. Currently, if a woman of color is able to point to a white woman in the workplace and say that they have the same title, the same job, but they're paid differently, she does not have an equal pay claim. That seems fundamentally unfair and not reflecting our values and principles as Vermonters. And so it's time that we take this law and expand it to the other protected classes of people. We have a lot of data that tells us that people of color, particularly women of color, are paid at a very low rate compared to their counterparts. We know the same is also true with people with disabilities. I think this is a very exciting law, and I'd love to see it get picked up and get passed this year. Any questions on that?
Nope, we're good.
Okay.
Yep.
And then the last one, which is honestly a controversial bill, and that is to correct the severe pervasive legal standard that courts have been using to interpret what harassment is across all those anti-discrimination laws that I've talked about. Now, the severe or pervasive legal standard came out of the US Supreme Court decision when a Black woman had experienced significant sexual harassment by her supervisor. And the court said, it's time that we allow harassment to be considered discrimination. And in order for someone to have a cognizable harassment claim, it must be so severe or so pervasive. The result of that US Supreme Court decision in the 1980s was that we have different circuits interpreting what severe or pervasive means. Some courts have found that even a supervisor or a coworker who is engaged in stalking for several months has not engaged in behavior that is severe nor pervasive. We don't know how long something has to be ongoing before it's considered pervasive, and we don't know how serious the incident must be in order to be severe, and that's problematic. It's unreliable. And if anything, the court decisions have actually leaned against the person who experiences harassment. The other problem with the severe or pervasive standard is that our judges do not know how to treat people who belong in multiple categories. So if you have a woman of color with a disability and she is being subjected to racial epithets, claims that she's crazy or that she has a disability and she's unable to do things. And then she's also subjected to statements around her, I said woman of color with a disability, her sex, right? She's also subjected to sexist statements in the workplace. Courts would view each of those things as separate evidence around discrimination on the basis of sex, on the basis of race or color, on the basis of disability, even though it's the one person who is experiencing, and usually one person who is the perpetrator of all of those statements. And last year, we passed this law as to housing. We were able to correct our Fair Housing Act. And I just want to share with you that in doing that, we were able to have a case reach reasonable grounds determination at the Human Rights Commission, where we had a woman who was a person with a disability and was receiving public assistance. And her landlord was calling her many different names across all of those protected classes. And because of passing the law last year and under the Fair Housing Act, we were able to get that case to reasonable grounds. And we're going to be litigating that case fairly soon. So I just think it's time that the legislature reviews when courts are using a standard that no longer reflects the way that people experience harassment in schools, the way that people experience harassment in the workplace. And I'd love to see the same language that was passed last year in housing and how that applied to places of public accommodations as well as workplaces.
Great. Any questions on that one? We are familiar with that, certainly, folks who've been here last year. So, Ella.
Thank you so much. Super great information for someone who's pretty new. I'd love to hear a little bit more about the litigation piece. So you just mentioned you are litigating or you will be litigating, and yet you don't have a litigator. And I'd just love to hear a little bit more detail about what would change if you had a litigation position on your team.
Yeah, so I'll tell you a little bit about what things were like before 2019 and then since. So before 2019, when the executive director was the only litigator, I want to say probably 2019, 2018. Before that point, the executive director was the only litigator. And as such, we would find reasonable grounds in cases. We would find that there was reasonable grounds to believe discrimination had occurred, and then we would pick and choose which ones we wanted to bring to court. And occasionally that would be maybe one case or two cases. And then on occasion, we'd say no to trainings and outreach so that we could do that. So it's really about shuffling work and so forth. When I became the executive director in 2018, I decided that I was going to hire a staff attorney who also had litigation experience, who might be able to assist. But we really couldn't say no to the investigations. We didn't want to do that. And so shuffling the work really wasn't all that helpful. Like I said, I've asked for a litigator every year. And I think it was to 2018 and 2019 where we got a little bit of money. Instead of giving us a litigator, we got a little bit of money added to our litigation fund, which was created by the legislature so that we can contract out services. So since 2019, 2020, we've been trying to contract out services. Now, the problem with doing that is that while we have a great relationship with a law firm currently, many times law firms don't want to take these cases. They are not, it's already been litigated it's already been in an investigation process for a year or more. We've already tried to settle it. So by the time a lawyer picks it up, it's going to go the long haul. We know that. And it should. We don't have legal precedents in Vermont. So few cases go to court. We're constantly relying on what the Second Circuit is doing. What is Massachusetts doing? What is New York City doing to help us interpret the way we ought to behave in the state of Vermont? So when we find reasonable grounds, I feel like our courts should hear those cases. And our lawyers, our private lawyers in Vermont don't want to take those risks. It's hard. So at the HRC, when we get that money and we say, we'll pay you hourly, can you take it? They're also thinking about time, resources, and the riskiness of that. And so eventually our money will run out and then we'll be in the same position. Having a full-time litigator ensures that we will always be able to litigate those cases without worrying about the underlying budget and using up that money. And also I think that I always try reaching out to multiple law firms, and we really have only had the interest of one law firm, and that's problematic. So that's why we need a full-time litigator as well. We need someone that is committed to the mission of the Human Rights Commission, who is interested in bringing cases that maybe are not slam dunk gonna win, and are willing to argue these cases to our courts and create some precedents in Vermont, and are comfortable with even potentially losing from time to time. Because a lot of these cases exist in the gray area. We have a case in litigation right now involving two homeowners, one harassing the other on the basis of national origin. This is a case that has never been heard in the state of Vermont, whether or not two homeowners can fall under the Fair Housing Act. It has under the federal laws, it has in other jurisdictions. We don't have a single case in Vermont that says, can we do this? And we're litigating that case right now through our contract law firm. But we need to have more of those cases. We need to bring more of those cases and bring them to our judges so that they can hear them.
Thank you.
Thank you.
Thanks for.
Any other questions for Bor? Tom?
I do. I might be a little bit out there on this. I haven't had a chance to really formulate it. There's a system for the Defender General to have public defenders subcontracted to take cases where they conflict out or they don't have the staffing. Is there any kind of way to facilitate that in your department?
Yeah, I did look at the way that the Defender General's office, does it too. But they have, and I can't recall, but well, in any case, I can't recall what the primary difference was in their budget, and I'm not familiar with the Defender General's budget overall, so I really shouldn't even speak to that. But I do remember having to research that at some point. The issue with the difference between our cases and a lot of the criminal defense cases is that they plea bargain almost 80 to 90% of the time. They're not going to trial. And as I just mentioned, we almost always are planning for a trial because we've been already attempted settlement for a year or two or even longer. And so it's just too risky for private employers to want to take on these cases for that length of period.
Thank you.
I think we're set. Thank you so much, Bora. And we may be having you back in over the course of the session.
Yeah, I want to thank you all so much for having me. Thank you all for the hard work that you do, especially this committee. And please don't hesitate to reach out to me if you ever need any questions answered, either privately or like individually, or if you are in need of training or outreach or anything that we can work on together. I really appreciate this and have a good one.
Great. Thank you.
Thanks, Bora.
Thank you. Okay, so Falco.
Morning. Yeah, it took a while.
Okay, sounds good.
Good job, man.
So good morning. Thank you so much for having me here today. My name is Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont. I use he, him pronouns. I'd like to introduce my colleague as well.
Hi, I'm Indy Schoenherr. I'm the Policy Advocate at the ACLU of Vermont, and my pronouns are they, them. I'm happy to be here.
Yeah, and I hope you all can hear me while I am masked. I have a 1-year-old at home who is bringing home all kinds of things from daycare. So I think this is helpful for everyone in the committee. So trying to do my best to protect public health here. Did you have a question?
Before you get your spelling, I want to make sure I have your name right.
Indy, I-N-D-I, and Schoenherr is S-C-H-O-E-N-H-E-R-R.
Indy. All right. Thank you again. Thank you.
So thank you so much for having us here today to introduce ourselves and the ACLU of Vermont. So I'm going to start just kind of high level explaining who we are as an organization and what we do, and then spend a little bit more time talking about how we've interacted with this committee in the past and how we see us interacting in the future and some of the issues we anticipate coming up in front of the committee that you might look at this year. So at the very highest level, the ACLU of Vermont is one of 53 affiliates of the American Civil Liberties Union across the United States. We have a couple affiliates in California, an affiliate in Puerto Rico, and we are the Vermont affiliate. We've been in existence for over 50 years. We started out as an organization largely of volunteers who would take on civil liberties cases, and our mission in its simplest form is to protect and advance civil rights and civil liberties that are derived from the United States Constitution and the Vermont State Constitution. So highest level, that's kind of who we are. Indy and I are the State House team for the ACLU of Vermont. So you're seeing the entirety of the State House team, and we testify on a wide range of issues. We also have 3 staff attorneys on staff at this point in time who bring litigation. So we do not do direct defense, but we do bring appellate cases and bring suit in cases of civil rights violations. There have been a number of suits that they have filed recently, but Indy and I are not on the litigation side, but focus more on the policy advocacy side and get to spend a lot of time with you fine people here in this building. So in terms of the issues that we work on, it's a wide range of issues where you often find intersections of civil rights and civil liberties. So we work on all the issues related to the criminal legal system in one way or another. We of course have to pick and choose where we have resources to engage because we can't engage on absolutely everything. But we also work on issues related to police oversight and accountability, bodily autonomy and reproductive rights, education equity, privacy and access to government and government transparency are kind of the high level issues that we work on. So that brings us to pretty much every single committee within this building for one reason or another at different points in time. But I find that we spend the most of our time within this committee. We spend a good amount of times with the Corrections and Institutions Committee down the hall, the Government Operations Committee when it relates to government oversight and accountability, and then also spend quite a bit of time over in the Senate and the corresponding committees. So likely you will be seeing me a good amount. This is my first time in this chair in quite a while. I think I was able to join you once last year as you were looking at the issue of courthouse arrests. But before that, there was quite a break where I was only able to see many of you on Zoom. So it's very nice to actually be back, to be here in person and be able to see you and talk with you all. So one thing that something that I handed out to you all is the ACLU Vermont Blueprint for Smart Justice. So 5 years ago, the ACLU of Vermont launched a campaign called Smart Justice Vermont, which had two primary goals. The primary goals were reducing Vermont's prison population by 50% from its peak, which was 2,200 back in 2009, and then also combat the racial inequities that exist within our criminal legal system. And there's actually a press conference happening in the Cedar Creek room at noon if you'd like to learn more about that. But I wanted to get into a little bit of some of the work that the legislature has done to actually address those issues over the past years, as well as the places where there's still work to be done. So the good news is, in terms of that goal of reducing Vermont's prison population from 50% at its peak, there's been incredible progress. And a lot of that has come from things like the initiatives, the Justice Reinvestment Initiative. So when you look at the overall numbers, Vermont's prison population is down about 40% from where it was at its peak in 2009. We were incarcerating about 2,200 individuals. We're now incarcerating about 1,300 individuals, which is pretty impressive. And a lot of that work was done in this committee, where folks were looking at opportunities to make sure that people who are engaged in low-level offenses we're finding alternatives to incarceration where that could better help support them into reintegrating into their community and rehabilitation. And we really are supportive and thankful of all the work that has happened to make that move forward. And I think those numbers speak for themselves, because this is an issue that is both of concern to the people in the community, people who get involved in the criminal legal system, but it's also an issue of state resources, because as we think about how we're using our resources as our state, incarceration is one of the most expensive ways to try and address these behavioral issues. I think it was yesterday, the Commissioner of the Department of Corrections presented to the Senate Judiciary Committee discussing the cost of incarceration. So I don't have the numbers right in front of me, but I think it costs about $95,000 a year to incarcerate someone in state in the state of Vermont, approximately $40,000 if they are incarcerated out of state in the private facility down in Mississippi. And then it only costs, under $10,000 in terms of having someone on some form of community supervision. So this is one of these things where we are looking at the actual cost of this to the people in their communities, the cost of their lives, the cost to those communities, as well as the cost to the state and how we use our resources. And that is one of the core tenets behind the Justice Reinvestment Initiative, is how can we be working smarter with our resources in order to best forward the goals of everyone involved in the system, which has been pretty phenomenal. For those efforts, we've seen millions of dollars reinvested in community programs that can help get at some of the issues that were raised as concerns in the analysis this Council of State Governments did as they looked at our current legal system. So that we've seen investments in data collection, we've seen investments in domestic violence programming, and helping to reduce fees that were barriers to people actually getting some of those services they needed to help rehabilitate themselves and reintegrate into their communities. So we are very proud of the work that the legislature has done and that we have been able to do with you all in terms of moving in that direction. And as you look at the Blueprint for Smart Justice, what this is kind of a roadmap for the number of policies that could be enacted to help get us towards that further reduced goal. And I think one thing you have all heard as a committee up until this point is where we're seeing the largest reductions, largest increases in that prison population right now is in the number of people being held pre-trial in one way or another. So at the height of the pandemic, our prison population was reduced down to about 20, I think the lowest point was about 1,225 people. And we've been seeing that number climb up slowly, largely due to the detained population. So folks who are being held before they've actually been sentenced. The sentence population has remained relatively stable, And I think what the commissioner said, part of that is because the justice reinvestment initiatives have been going into place. And what we learned through justice reinvestment is one of the biggest drivers in terms of prison admissions was folks being returned to an incarcerative setting because of violations of community supervision. This is one of the places where we saw the biggest increases and one of the biggest drivers in this churn in populations who might be let out, have some sort of violation, many of them technical violations that are not in fact new crimes, and then being sent back in, often for shorter periods of time and then cycling in and out, and sometimes for longer periods of time. So those crimes can end up sticking around and disrupting someone's life for quite a long time, costing the taxpayers money, and then also just increasing the number of people we had incarcerated at any one point in time. Also creating that churn within the system, which makes it hard for people within the Department of Corrections to actually program and figure out how to use the facilities appropriately. So through the Justice Reinvestment Initiative, there are a number of ways that this was addressed. And I know this was a joint effort between this committee as well as the Corrections and Institutions Committee. Some of those initiatives included moving to a system of presumptive parole, which basically says if someone has met their minimum sentence, the presumption is they should be put on parole. And that is an improvement over the previous system because Vermont was one of the few states that used a system called furlough in the way that we did. So I think many people have probably heard of furlough, and probably the most famous case of furlough what people know about is Willie Horton. We have the idea that someone is let out for a specific event for a short period of time, usually to go to a funeral or something like that. In Vermont, this was used in a different way, where it was an extension of the prison walls into the community, where what was happening is most people, once they hit their minimum sentence, they were released into the communities, and then they were under a tighter form of supervision than they would be under parole, with less due process. And so smaller violations would return them to prison more quickly than they might without the ability to contest that, which is different from the process of parole, which is what we're moving to. So trying to add more due process protections there. And also we've included protections that allow for people to have an attorney contest some of these revocations for longer periods of time. So those are two of the main initiatives through that Justice Reinvestment Initiative, which I think has helped help keep that sentence population lower as we saw those reductions coming in through the pandemic. Another major initiative that was, I believe this committee looked at, as well as the Corrections and Institutions Committee looked at, was the idea of earned time. And that directly relates to the idea of truth in sentencing that we heard earlier. Vermont used to have a system where people could earn time off their sentences for good behavior. And then Vermont transitioned to a system of truth in sentencing where the idea was, if you do not have that incentive there, then prosecutors would be lowering the charges in order to, sometimes the idea was prosecutors were charging up because they said, well, if this person was actually going to get this much time off their sentence, then what we should do is we should charge up to make sure that they're serving the amount of time we want them to serve. What we saw is there wasn't really a change. There wasn't really a change in terms of how the level of sentence that people are asking for. And so that was one of the major recommendations of the Justice Reinvestment Initiative. And we have instituted earned time within our correctional facilities. And that's another way that people are able to reduce their sentences for good behavior and then still be going in front of parole boards and other mechanisms to make sure that they are safe to re-enter the community. The other major component of the Justice Reinvestment Initiative, our Smart Justice campaign, is looking at the racial disparities that exist within our criminal legal system. So this is an area where we actually have not made as much progress as we have in terms of reducing the overall population of those people incarcerated in the state of Vermont. So if you look at this report, and this came out in 2019, a Black person in Vermont was about 7 times more likely to be incarcerated than a white person in Vermont. And when I checked the statistics this morning, those numbers are just about the same. Black people account for about 1.5% of Vermont's population, account for about 10.5% of our prison population. And this is a major concern. And so this is why for many years, this committee worked diligently to try and move forward legislation to help us get better information about what is leading to those racial disparities. And that's why we are overjoyed to see this committee and your colleagues last year pass legislation, create the Bureau of Racial Justice Statistics. We think this is a major step forward that will help us identify some of those points we're seeing drive those disparities in the criminal legal system. Before we get the information from the Council of State Governments, there are some things that we do know now in ways that we can address this, that this committee actually took up last year. And one of the major ways that we can look at the disparities is in charging and sentencing for drug possession and drug crime. So one of the major the findings of the Council of State Governments were that Black people in Vermont are 14 times more likely to be charged with a felony drug offense than a white person in Vermont. And they did an analysis to dispel some of the myths that have been going around saying, this is all because these people are coming from out of state, and that's what's driving this disparity. And they're able to dispel those myths and say, no, this is how the system is working now. There's disparities in charging, and there's disparities in sentencing that are moving forward within our system, regardless of where someone is coming from, that we need to address. And so that's why last year, this committee spent quite a bit of time working on legislation that would try and defelonize the personal possession of narcotics. And this was one of the major recommendations from the Council of State Governments. Unfortunately, that legislation did not move forward in the Senate. And I will say that has been a theme that we have seen with the hard work of this committee in a number of areas where we've tried to look at sentences and adjusting sentences to more appropriate levels in line with recommendations from the Sentencing Commission and others, because as we look at what's driving the prison population, increase in sentences over time is one of those major drivers, because since the 1980s, sentence time lengths have been slowly creeping up and up, and that has led to that increased population. So I guess part of what I want to say is thank you to this committee for your commitment to those issues and for trying to move forward sentencing reform in a way that is thoughtful. It is frustrating those efforts have not moved forward further, but when we look at what we can do in terms of making sure we're only incarcerating people as a last resort and when necessary, I think sentencing is one of those major concerns, and looking at bail and issues of pretrial detention are two places where we continue to move forward. I think we've done a lot in terms of the Department of Corrections in the back end. We need to continue to move up the system and look at some of those other options for how we both reduce this prison population and then address racial disparities. So that's a little overview of our view of some of the criminal legal system. I guess one thing that I would like to address, just I've heard this in testimony some this morning and a number of other places, is this discussion of the perceived rise in crime, and that is part of the predominant public narrative at this point in time. And I think when we look at this issue, one thing that we want to continue to highlight is that within the pandemic, the cracks in our social safety net were really laid bare. We are seeing a major crisis in terms of housing, access to mental health services, access to substance use and abuse and treatment services. And many of those lack of services can be behind criminal behavior. I think people can parse criminal statistics and look at, is crime really going up? Is it really going down? People can choose whatever different statistics and see different pictures. But I think that one place that we hope that we can find agreement is that if we want to address some of those issues of crime, looking at the root causes and making sure people have the supports and services they need is where we hope that the legislature as a whole, I know you are not the appropriations committee, but you can help make that case to them that those are places that we need to help support folks. And I guess finally, in terms of other issues, which I will likely be in front of your committee on probably quite soon, is the issue of reproductive rights and bodily autonomy. So as the chair mentioned when he was speaking with the Chief Justice, the decisions of the Supreme Court earlier this summer when it came to reproductive rights created a seismic shift in the landscape around the country. As a state, the state of Vermont this November passed the Reproductive Liberty Amendment enshrining reproductive rights and bodily autonomy into our Constitution, which is something we were heavily involved in. And I know this committee and other committees in this building were very heavily involved in making sure that they actually made it to the ballot. So we appreciate that. But now we are hoping that we can take the next step in trying to make sure we're protecting patients and providers who are engaging in both reproductive health care as well as gender affirming care, in practicing, in providing medicine that is legal here within the state of Vermont and minimizing any negative consequences they might feel from states trying to reach over their borders and regulate legal activity happening here in the state of Vermont. So as those bills come forward, we look forward to working with you on that. But the simplest idea is we're trying to protect the providers and patients here in Vermont who are doing things legally and making sure that we're not seeing overreach from other states that might try and criminalize that behavior. So that was a lot of me talking, and I'm sorry if I went too fast. So I'm happy to stop for now and take any questions, or to cede the chair if that is helpful.
Sure.
Yes, thank you for all that. And I appreciate it because for me, being on corrections last year, it kind of built that bridge from the work that was done last session and that need to now work upstream further on it regarding the incarcerated population. So you mentioned the detainee population and how that is a big chunk of those who are incarcerated. When we were hearing about the court backlog, I guess it was last week, we heard that those cases are being prioritized, that's great. That's helpful to hear. I'm curious, other thoughts you have on what we can do to address it. You mentioned bail. What are other things we should be looking at?
Well, I think there's a proposal put forward in this committee in terms of how we can clear some of those backlogs in terms of dismissing some of those cases where they are not posing a public safety threat. Of those numbers, I think there's about 400 people who are currently detained free trial in the state right now. Of those people, I believe approximately 190 of them are being held on conditions of bail. So I think we need to, and as folks may know, in this state, bail can only be used as a means to try and prevent someone from fleeing and not actually showing up for their court date. It is not meant to be used as a means to try and protect public safety in terms of someone being an actual threat to the community. That's why we have hold without bail statuses. So I think there's a number I think there's going to be at least a couple bills coming forward this year looking at what are those conditions that someone should be held on bail and when someone should not. So I think that's one way to look at it. I think dismissal of cases where people do not pose a public safety threat is another way to look at some of those backlogs as well. So those are at least two proposals that I have seen that we would be supportive of.
So if somebody from another state that had restrictive abortion laws came here to exercise their reproductive rights, how can another state charge them with anything when they didn't break any laws in their state?
Well, I think the short answer is that they shouldn't be able to. But that does not mean that there aren't legislators in other states who are trying to get creative and push the boundaries of their ability to regulate behavior happening in other states. There was a good report on NPR about this just the other day, where you had a constitutional scholar saying, with the Supreme Court and with their willingness to, move forward and allow state laws that might not have been seen as constitutional before, that there is a concern that states are going to be trying to test the boundaries in terms of how they can use long-arm statutes to try and, say, criminalize the travel out of a state for the purposes of getting abortion. Often, another way that states are trying to do this is through civil suits as opposed to criminalization. So what they're saying is, well, if that doctor provided services to someone in another state who is a resident of our state, you're going to, similar to the SB 8, which was passed in Texas, which allows private citizens to then bring vigilante suits against providers and people who aid and abet in this person receiving health care. And so there are ways to try and address that in terms of the ability for countersuit and other things like that. But I think short answer is we don't believe that they should be able to bring those types of suits. But
The fear is that this may happen.
Yes, and one of the fears is, especially as there's a number of other legislatures going into session right now, looking at how could we possibly try and criminalize this behavior or disincentivize it through civil suits, and what has been put in place. So I think you're probably going to hear more about this soon. There have been a number of other states that have tried to put protections in place, including Massachusetts, New York, California, and Connecticut, referred to as shield laws, trying to protect those types of, overreach from other states that are trying to either criminalize or disincentivize them.
If we enacted some kind of a shield law, how does that have jurisdiction in another state?
We cannot tell another state how they can legislate.
Right.
And that's what we can do is we can say things like, if there is a suit brought against you on these grounds from another state, we will give you grounds to sue back and nullify that lawsuit. That is one way that folks have looked at that. Other things are protections for medical practice licenses. So if folks are providing these types of services, we can make sure that even if they're licensed in another state, they might lose their license, they can maintain licensure here in Vermont. And then other ways that folks have tried to look at this is just kind of non-cooperation, right? We are saying as a state, we are not going to cooperate and assist in your investigations or in you bringing these suits from other states that we do not think are valid and for activities that are perfectly legal here in the state of Vermont.
We'll be having a lot more on this next week. Wednesday and Thursday, we'll have a number of witnesses discussing the bill that will be introduced fairly soon. So I'm sure, thank you for that introduction to next week.
Yeah. I knew it might be coming up soon, so I wanted to tee it up a little bit.
Yeah, it seems like you're prepared and ready to go on that.
Which is awesome.
So,
We all should be.
any other questions? I had one question, or maybe a couple questions. I think actually you answered one. I was curious how many of the detainees were on bail conditions, and I think you said 190.
I think that's what was shared with the Senate Judiciary Committee yesterday. Yeah.
We'll probably want to look into at least whether or not we take up any of the bills that you mentioned coming this way. At least we need to have a little better understanding of who's being held on bail. The other question is interesting. How much it costs for to incarcerate somebody for a year. The $95,000 figure. Last I had heard, it was like in $60,000 range. My question is, and actually maybe Karen from your corrections days know the answer is, I'm assuming that part of that cost is because most of that is a fixed cost and we're applying it to fewer inmates. Is that right? And so
that might be part of it. And I think, so this information came from testimony from the Department of Corrections to Senate Judiciary. So I'm happy to forward that to you just so you see that. I think that does include DOC overhead costs. And I think that calculation might take into account that there are fewer people being incarcerated, and then those costs get spread out more over that population. I do think you're also looking at inflation, where I believe it was when we were engaging in just reinvestment just a few years ago, the statistic for what it costs to house someone out of state, I believe was around 27,000. And I think that's gone up to 40,000. But it's, I think when you look at where you see inflation across the board, it's usually in personnel, right? We're looking at the personnel costs of trying to incarcerate these people, find people who are willing to take those jobs. I think that's where we're seeing a lot of that increased costs happening. So I believe that we're seeing some inflationary pressures, and I think also it might have to do with the fact that it's being distributed over fewer people as well.
Any other questions at this point? And we will certainly see you on when we get some bills in front of us that you're interested in. So,
all right.
Thank you very much.
Thank you so much.
So, Coach, how much time do you need?
Well,
are you
granted we set aside, a block of time, but being that this would be between us and lunch, it's been a long morning.
We can reschedule.
No. I'd like to start.
Okay, good. Yep.
And at least engage the committee in the discussion. And we can pick it up again. I can adjust that.
Okay.
And still get us out of here at least 10 minutes to 12 or a quarter to 12 so that everybody can maybe get a head start on the lunch line. No, I thought that would have at least garnered at least one bag of nuts.
Fair.
You already had them. 11:45.
Oh, see you.
Sorry, I know. I'm sorry.
Whatever it was. But so if we could, would you mind passing those?
Oh, yeah.
Excuse me. Thank you. I hate that when I hear that. So, as soon as she lets us in, I'll give you a quick background on how we got to this. And now, if we can go. Yeehaw. So, it's easier sometimes when you're out.
I think you're put on mute too.
Yeah, so Mark, your volume needs to be all the way down.
Okay, so, sorry about the technical stuff there. But I just wanted to introduce you to the Social Equity Caucus. And, you know, it came into being in 2019. And it started with approximately 20 legislators and a handful of community members and organizations. And then after about a year of organizing, you know, our membership increased to over 75 legislators and over 200 outside entities. You know, last year, or I should say last biennium, and then biennium before, over that time, we had a lot of, let's say, activity and accomplishments, as a result of the work of the committee. And especially with joint legislative hearings that we did along with a number of different committees and the caucus itself. And as you can see, those bills that we worked on were a lot of the criminal justice bills, and most of them made it across the finish line in both bienniums. So, we're really proud of the work that resulted. And probably one of the coolest things was when we put together the SEC work group. And from that work group came a number of initiatives. But the biggest part of it was flipping the paradigm of members. And you'll notice that we had 18 to 20 members, on that committee. And of that group, 14 were community members instead of how it had been, where 14 would have been legislators and professionals, and then a smaller number, 4 or so, of the community members. And as a result of that activity, in the second biennium, the one we just left, we increased the size of a number of community members in the policing area, and also in other committees that kind of picked up on, how can you, make a decision without hearing from the folks that are most affected, by it. So that we feel pretty strong about that particular achievement. So when we get to during that whole time, we were trying to come up with a tool that could help all of us as we look at our legislation on the front end, so we don't have to come back 2 years later and go, we kind of left out a whole bunch of folks, along the way. So that's where the probing equity questions came into being. And those up. That's the sheet that's in color. And, basically the challenge, was, how do legislators determine and then address systemic equity problems? Okay. If race is a fact of a social construct manifested through caste systems and arbitrary hierarchy of power, why is it so challenging to undo this? How can legislators value our collaborative humanity without furthering, perpetuating white supremacy culture? And, we do a whole series of trainings on the history component, of, our country, basically, that we haven't looked at before. And that, there's going to be a mini training this afternoon, and then during the course of the session we'll be doing other ones, because there's so many things that were left out of the history books. And it's not that they didn't happen. You have to think of where the history books were written. And one of the things we all know about history is history goes to the victor. I mean, when you go back to the Egyptian times, a pharaoh would win, and he'd erase the name of the pharaoh that was in front of him. You know, I mean, you know, just scratch it right out of the, you know, the logs, the annals of history. So that perpetuated up to our time, where if you were in the point of control, you had control over the history, or at least the written part of it. So let's take a look at the probing questions themselves, and you know, the overarching goal. You know, how does this proposed legislation distribute wealth and resources to increase social well-being for the racial ethnic groups most adversely impacted? And that's easy to test, you know, as we're working through, you know, a specific bill. And it's a question of having that as a thought pattern. You know, are we ensuring that the least served Vermonter doesn't get left out? And when I make that statement, that's that least served Vermonter, you know, could very well be anyone. Okay, it could be a person who's getting Meals on Wheels, it could be, and it doesn't matter what their ethnic background is. You know, if they are disenfranchised in the sense of on the lower end of the information scale, or any of those. Remember when Board talked about the protected classes? So women, people with disabilities, you know, racial or ethnic backgrounds, you know, people, you know, who share different lifestyles. All of those are protected under law now. So if they're protected, we need to make sure we don't leave them out. Because what happens is, often, if we don't ask ourselves, did we include, we usually leave some folks out. And if we do that, that's when we have to come back the next year or the next biennium and say, well, we've got to adjust this bill because we left 20,000 Vermonters, you know, out of the equation. And that's what this is about, you know, and making sure that we don't do that, and have a tool basically to do the, you know, that analysis, you know, like under question 2, you know, which individuals benefit from the proposed bill? And you can ask yourself that question, you know, if BIPOC, LGBTQ, you know, plus disability, migrant communities do not benefit, how can they? You know, what is leaving them, you know, like out? In some cases, it's a very simple thing. Do we do translation services? You know, do we ensure that we provide those? You know, so that if I'm operating a new business and I decide to hire an Afghani, you know, refugee, can I get some help with, you know, translating so that I can offer that job? You know, especially when we're talking about growing our workforce and also our tax base. Because if they're here, they're going to be paying taxes, they're going to be, you know, providing, you know, service. And, you know, I had an example from a constituent who does the Vermont modular homes. He said what he would do if needed, because he also has a lot of apartment buildings that he owns too, is he would provide housing for carpenters who were willing, to work. Because he can't get them. He can't, like keep, a steady flow and grow his business. He's behind the eight ball. And he's building a renewable entity. I figure it's the only net zero modular that's approved by HUD. And so that took a lot of work to get that accomplishment from a Vermont manufacturer. And he's kind of being, stifled by some of our work. It could be more expansive. Why? Why is this legislative committee seeking to address an issue? Listen to what Mort talked about, this morning when she was talking about don't darken my door. A lot of women, especially when they do that exit contract, end up losing all of those opportunities to come back to state government. If they file, sign that agreement. And that shouldn't be. Like they were saying, it's 14,000, employees. We're the biggest employer in the state, and so you get, knocked out of, state work, and where are your other opportunities? So those are the types of questions that we need to continue to, to ask ourselves. Is the purpose of this legislation to uplift the community most adversely impacted? Again, within that construct, looking at severe and pervasive, for example. With that bar being as high as it is, a bill like we passed in the House that protected that group of folks, actually everybody, because, any of us could run into that. He took a state job, and all of a sudden, that particular manager, you had a falling out, and it was more personal than it was performance related. So you're out, of the mix, because you might find that in another agency, you'd be able to go, just rise, to the next level. Is the purpose of the legislation to uplift communities most adversely impacted? When we listen to Falco talk about the numbers of people of color that are incarcerated per capita, is the work that we're doing with a particular piece of legislation helping that cause or not? That, and it's a question that we should ask, along the way, and regardless of what we might think it does versus what we know it can do, always has to be part of our thought pattern, basically. And here's the big one under the why, is what evidence has informed the bill? do we have data, to support a particular contention? Do our stop patterns tell us certain information? Do our incarceration rates tell us certain things? And then how do we disaggregate that data? What types of cases, are bringing people into the system? And then how long are they in the system? And then the opportunities for exiting the system. And those are critical. How is the committee being informed by people most impacted? I think the witness we heard from a couple of days ago on the bill.
Use of litigation.
That's real. Those are folks that are impacted. And sometimes, and over time, I think, and hopefully we don't find ourselves doing this as a committee, but I've seen in other committees that I've been on over the years, we don't dig deep enough, into the who and the why. And I'll give you, an example, like bringing in, teachers when I was on education. We had to fight to do that, to get it firsthand, and now I think we have an opportunity because of COVID with this kind of, technology to reach out easier, to get folks, in. Because one of the biggest problems was if you were trying to address an issue occurring in, what we used to call the banana belt down in Bennington area, because it was so long. And it was hard. It was hard to get people. It's 104 miles from Hartford to Bennington. So it's 57 more miles from Hartford to Montpelier. So, you get in your car to come and testify for 10 minutes. That's like a 3-hour, one-way trip. And so getting witnesses in, who are, let's say, credible witnesses, it was difficult. It's a lot easier now, but I think it's imperative that we do hear those stories, those firsthand stories, so that when we make our decisions as legislators, they're valued or of more value. We hope they're valued, but we want them to be of a higher value. As we move through the engagement, that whole idea of the structure of committees and working groups actually came from the community. We did a number of surveys over the first year of engagement, and one of the things that we found were the same 12 people, basically. Well, maybe not 12, maybe 5, kept showing up in the witness seat, and we kept hearing from the exact same people all the time. Okay, I kind of know that story, and let me go back to the original. But to get more voice, from the community was critical. And so too, in committees of jurisdiction, where you've got, the Criminal Justice Training Council, for example, that has jurisdiction over law enforcement licensing, with its tiers, its training. It was predominantly made up of past prosecutors, the past attorney general, and then law enforcement itself. And it had like one or two community members, on the council. And with looking at civilian oversight, or at least participation in the process, it only made sense that we would expand the size of that group and include more regular people, who are impacted by that, in that jurisdiction piece. And that came as an outcrop of this work in developing, the tool, so to speak. So I think what I'd like to do is, just quickly go through the last couple of things, and I think you've got a flavor of what this is about. And this is changing our dynamic, because usually, I think you can already see where if you don't do it on the front end, you're gonna come back and have to fix it, later. So if any time that we have an opportunity to take that look, at what we're doing, so that we can put together a better piece of legislation or policy, we need to take that up front. And we'll keep, talking more about it. I think I'd like to, at this point, kind of thank you for your indulgence, and we can all kind of head up the rise and grab a little nutriment.
Excellent. So thank you very much for going over this, Coach. And I think what I'd like folks to think about is how to keep these questions and issues in mind as we're having legislation come in. I don't think we're going to, we talked a little bit about this in different committees, maybe doing different approaches. At this time, I don't think we're going to formally, the whole committee walk through every bill with these questions, but we all should keep these questions in mind as we're going into the bill. And because some bills are more obvious than others, and some bills don't seem to necessarily get these questions. But we want to keep, them at top of mind. And we can talk a little bit later if we want to start figuring out something even more formal to do. But just initially, as we're kind of easing into this process of having these questions, ask you all to kind of keep those in mind as well. Ken?
I think the big thing, just to wrap this up, is that now that we're back in person, it's much more easier to have this open communication where we can go, because I can go and see Coach wherever, and the stuff I want to, or I have a question on or something like that, I can talk to him one-on-one, that it helps us a lot more in here. And I think, again, the open sit around the table that we haven't had for 2.5 years is huge with it. So, and I totally look forward to that. So,
any questions for Coach at this time? You know where to find them if you have them. But no, go ahead, Ellen, please.
Not really a question, but I just say, I just really appreciate seeing this kind of tool laid out and all the work that I'm sure for over many years, as you described, Coach, goes into getting to a place where we have these tools. And I think it just, one thing that feels maybe a little bit missing as a group is to establish some agreed upon goals and why we even use a tool like this. And I think we sort of know in the back of our minds that we share the goals of not making sure anything we pass out of the committee isn't discriminatory, isn't going to perpetuate issues of discrimination. And then we also, many of us share goals around actually repairing harm, which is down here as one of the questions. So I guess I just want to acknowledge that this comes out of a place of sort of shared goals and intention, and tools like this, sometimes you have to use them really in an awkward way in order to change the paradigm that we all have lived in and come from in whatever cultures and ways that our society does stuff. So it's sort of like awkward to start with some of these questions sometimes. And, maybe it's worth taking a bill and going through every single one as an exercise to sort of push ourselves to learn what impact it has to ask a bunch of somewhat obvious and yet also somewhat awkward questions. So I just acknowledge the sort of point in a process of trying to change our system that we're at, where we have a great group of questions that we could ask on every bill, might not want to ask on every bill, but keep in the back of our minds and just sort of acknowledge some of it.
So with respect to that, I mean, perhaps we can do this exercise. Probably won't happen this week or next. I think we're pretty booked. But maybe take a bill that we are planning on taking up and run through it. So I'm just thinking, for instance, I'm hoping that we get the driving with the license suspended bill, which was sent to transportation because I didn't get to Jill in time to say that he could come here. But hopefully we're going to be getting that bill, and hopefully that's one that we'll be looking to move on next. Either that or the restorative justice bill, depending on when that comes out. There might be a bill that we can really use for that exercise.
To test it, because what you're gonna see is when you fast forward through it, you're going, we know that we want it, yes, and then other bills are gonna go off, and there's just so much that needs to be ensured versus another bill that you go through and go, okay, we got this, we're on target, But as long as we're using that mindset, I think that that's what's going to change the quality of our policy.
I just want to just appreciate your comments.
Yes, definitely. Thank you.
That was right on. Did you write this? No.
All right, I appreciate this. So we will see you at 1 o'clock, or do folks need a little more time? Because I don't think we're gonna, what we have at 1 o'clock is probably not gonna take that whole hour. And then we have Terry Carsones coming in at 2 to go over what they would like from the BAA. So should we start at 1:15?
Sure.
Better for people? So we'll start at 1:15.
Perfect.
Nina, if you could just shoot an email.